Garcia Guadalupe Gonzalez, you'll need to press *6 on your device to unmute. Good afternoon.
Good afternoon.
Thank you for being here. All right, do I have someone on behalf of the defendant, Marissa Rodella?
Present.
Good afternoon, Ms. Rodella.
Hi.
Are y'all by any chance near each other in the same department, same house?
Yes, we're in the same room.
Okay,
Yeah.
maybe y'all can be on the same device if that's possible. Otherwise, what's gonna happen is we're gonna get a lot of calls. Phones are right next to each other.
Oh, okay.
Okay, if you wanna mute one of them, that would help. Okay, I can hear you both then. All right, Ms. Gonzalez, why are you seeking to evict Ms. Rodella?
Hold on, sorry. Distraction there. For non-payment of rent.
Okay. How much is the monthly rent between the parties?
6 is what I was paying.
6.
How much is the monthly
rent? 1,125.
Ms. Gonzalez, how much rent does Ms. Rodella owe each month?
6 a month.
$6 or 600?
I'm sorry, 600.
600, okay. And what months of rent are unpaid?
For sure, May, April.
I think just May and April.
April and May?
Correct.
All right. Is there any government subsidy on the rent?
No.
All right. When was the notice to vacate given to the defendant?
What was it, Kat? When was she saying?
It said that it was filed the 6th of this month.
No, not when it was
but
filed. When did you give her a letter that said, hey, you owe me rent, move out or pay?
You never gave it to me. He gave it to me. He gave it to me, not the landlord,
That's
not the
fine.
homeowner.
It doesn't have to be from the landlord, so long as you've got a notice to vacate. What I hear is you've got a notice to vacate, that's actual notice. Okay, Ms. Rodella, is it correct that the monthly rent is $600?
Yes.
All right, and are April and May unpaid?
Let's see. I gave you what, 100, I think it was.
You've given her money here and there.
Yeah, I've given money here and there.
Okay, but you did not give all 600 in
No,
in
not the full
April?
amount. No, ma'am. I was unable to pay the full amount.
All right, Ms. Rodella, I'd like to give you credit for that which you've paid. Can you, with any specificity, testify as to how much money you've paid in rent since April?
I know I did give you 100 at the most, but I don't know about anything else. Was there anything else that I gave you besides the 50 and then the other 50? No, no, it was just the $100 that I had given her.
All right. Well, Ms. Rodella, I appreciate that. With that information, Ms. Gonzalez would win her case for a non-payment matter.
Okay.
Is there any information you wanted to share with me? Because what I'll just do is make a calculation then.
Okay. I don't think there's anything else. No.
Okay. Well, here's the numbers, y'all. I appreciate it. Everyone's been very reasonable. For May, I would take the $600. I divided it by 31 days. That works out to a certain portion per day. And today, 26 days of the month, the prorated portion through today is $503. Okay. So there'd be 600 for April and 503 for May, but I would give you the credit. Everyone seems to acknowledge there was $100 paid, so it would be less that. So it would really be judgment for the plaintiff with possession and back rent of $1,003. That's 500 from April and 503 for the month of May. Altogether, 1,003. To that, Ms. Gonzalez, you would also be awarded your cost of court, so what it cost you to file the suit. And then Ms. Rodella, Ms. Gonzalez, you both have 5 days to appeal that. I would put the appeal bond equal to just 1 month of rent, so that would be $600.
Okay.
All right. Any questions?
No, not
All
my
right.
part.
Well, thank y'all very much then. If there's no questions, all parties are excused.
Okay.
Thank you.
Thank you. Very best of luck to everyone. I appreciate it.
Now, what does that mean?
Why did the landlord file for this eviction?
It's a non-payment of rent,
Okay. How much is the monthly rent?
$627.
Is there any subsidy from the government on the 627?
There are not.
Okay. What months are owed?
March, April, prorated May.
Was this a CARES Act property?
Yes,
Was 30 days provided?
yes.
When was that done?
March 23rd, 2026.
How is it?
Posted inside the unit.
Okay. All right. And was the defendant able to pay?
She was not.
Okay. All right. Good afternoon, Ms. Evans. Thank you for being here. Those who heard this cases are a financial case, so I know it's unfun. We do get a lot of these. So my first question is the monthly rent amount correct? Is it $627?
Yes,
Okay. And then is it correct that March, April, and May remain unpaid?
yes.
All right. Ms. Evans, with that information, the landlord would win the case today. Can I answer any questions for you? Can I give you information about the timeline or next steps, any of that?
I did request assistance from a church, and they say a check is forthcoming.
Okay.
Could I please ask that that be not for the full amount, a very low amount? Could I ask that that not be applied to the judgment? That I just pay the entire judgment myself, or
I'm not able to do that, Miss Evans. I give you some information though. And Ms. O'Neill, if you want to add in here, this is where, so Ms. Evans, I can give you the legal, kind of the absolute minimum, what you are absolutely guaranteed. And then certainly you can talk out to your landlord and there may be other things between the parties, right? So here's what I can say. The judgment today is going to be, and I'm going to calculate it out. It's going to be for March, April, and then we'll prorate it amount. I got 525 for the month of May. So let me just go ahead and do that. 525. So total judgment today, is that right? I'm not good with math, y'all. Plus. Total judgment I calculate is $1,779. That's rent. That's all of March, all of April, and then it is 26 days for the month of May. I'm not including the entire month of May. That also doesn't include things like late fees or utility bills, any other amounts of money that might be due and owed under the lease. That's still a part of your ledger. So if you were to call the landlord and say, what do I owe? Very, very likely the number they give you will be larger than the number in court. Part of that is that state law does not allow the landlord to collect late fees or utility fees or repair fees in the eviction. It is just flat rent and possession. But under the contract, those things are owed. I'll also highlight that you have 5 days to appeal. And anecdotally, I'm not saying this is true. I just say that what I've heard is because today you are being evicted and you will have a judgment issued against you, contact the legal aid group that you've reached out to, that you've applied for assistance, and let them know that it's happened. It's not a possibility. It's coming. It's here. 5 days further, the landlord has the right to possession. Occasionally, what I've been told is that can accelerate funds. That may also be something you talk to the landlord about. If funds are received, whether or not the landlord is willing to let you stay or do anything with it, if you give them money, you don't owe them the money twice, right? So it's like today I'm going to give an award, I'm going to say you owe them $1,779. If you gave them $1,779, you don't owe that money again. You may still owe things like late fees or utilities, but like once they get the money, they get the money. They don't get it twice. Okay. So if the third party decides to pay money on your behalf to the landlord, that money would reduce any outstanding this judgment or the outstanding ledger. They don't get to get the money twice.
okay.
Okay. All right.
Okay.
Ms. O'Neill, anything you'd want to share? I'm just giving Ms. Evans the generic information about the law and all of that. But sometimes,
Sure. Am I allowed to speak to Miss Evans directly?
as long as you're being polite, but yes.
Yeah, no, I just wanted to make sure. What was your plan with the rental assistance? I'm sorry, can you repeat it?
Well, the rental assistance is a very small amount,
Mm-hmm.
and it is from a church. So I was going to request that it be returned to the church and I be held responsible for the entire amount.
Yeah, we can do that. That's fine.
Okay. Thank you.
I'm going to give y'all some final information. So the judgments for the plaintiff, $1,779 plus cost of court. Either party can appeal. To appeal, I would double the rent, so that's $1,254. Certainly parties can seek to appeal on either side. Also, Ms. O'Neill, Ms. Evans, if parties come to some other agreement in the next 5 days and the landlord notifies me of it, sometimes the landlord says, we want to set aside the judgment, defendant moved out or we got paid or whatever it is. That's something, but it's only from the landlord's position, okay? All right. Good luck, everyone. I really appreciate it. If there's no questions, all parties are excused.
Thank you.
Thank you.
Thank you very much.
This is failure to pay rent. Rent is $11.85 a month. She owes April and the prorate of May for a total of $2,178 and back rent through today. There's no government subsidy. 30-day notice to vacate or notice to pay was mailed and emailed on April 6th. We're seeking back rent, court costs, and possession.
All right. Good afternoon, Ms. Melkor.
Good afternoon.
So my first question, Ms. Carco says this is a case related to finances, and that's actually every case I've heard today. So not uncommon, just not fun. My first question, Ms.
Yes,
Melkor, is the monthly rent, the flat rent, is it $1,185?
Yes, ma'am.
Okay. And then is it also correct that April and May remain unpaid in full?
Yes, ma'am. I had a miscarriage and I lost my job, so I wasn't able to pay it.
Ms. Melkor, I do lots of empathy, and I'm sorry that's you're going through that.
Yes, ma'am.
Circumstances in life are very much difficult. Those are not a defense. So let me give you information, and certainly you can talk to the landlord, and there may be some options available still to you. Okay.
Yes, ma'am.
All right. Today, that's a judgment for the plaintiff. It's a non-payment situation. So the amount of rent is going to be the $21.78. And if you were kind of in disconnection, so I'll just highlight for you. The judgment the court can give the landlord is just about rent. It cannot include late fees, utility fees, cleaning fees, pet fees, any of the other stuff that might be due under the lease, okay?
Yes, ma'am.
So we give you a number that quite likely is smaller than the number the landlord would have for kind of a final move out balance. And that's the reason for that difference. So today the judgment is $2,178, and that is rent for April and then 26 days of rent for the month of May, not the full amount, all right? The only additional thing the court adds to it is the cost it took for the landlord to file and come to court. Typically, that's about $130 or so. Either one of you can appeal it. Because this is April and May only, if you wish to appeal or if the landlord wish to appeal, the appeal bond will be 1 month of rent. It is $11.85. And Ms. Melkor, that can be done with cash or surety or an affidavit of inability. We send all that stuff automatically to both sides. Ms. Melkor, if you
Yes,
take no action, you have at least 5 more days before the landlord can legally remove you or your property. All right. You get tomorrow is day 1. So you have at least 5 solid days before the landlord can take any action to remove you or your property.
Yes, ma'am. I do have a question.
Absolutely.
So I had already moved out of the property. I moved out on Friday. And because I spoke with the leasing management and I told them that I had 2,700, my balance was 3,100 and I had 2,700 and I offered to pay that. They told me that I wasn't able to pay that unless I have the full $300,000.
Okay.
I $300. And they denied it, and so I moved out. I obviously used that money to move out.
Okay.
So you're saying I only owe the 2,100?
No, Ms. Melkor, I'm saying the judgment for actual rent unpaid is $21.78. The landlord may send you a bill for more money
Okay.
because they may still be trying to collect unpaid utilities or cleaning fees. I always just highlight that the number the landlord's balance says is probably going to be a different number than what the court judgment is. Because in court, they can the only thing I can give in an eviction is actual rent. But under your contract, you may very well still owe additional things like utilities or cleaning or late fees. I'd say contact your landlord and they can give you information about what they claim your outstanding balance is.
Yes, that's understandable. Thank you.
Absolutely. All right. Well, Ms. Belcourt, very, very best of luck to you. Thank you for coming today. If there's no questions, all parties are excused.
Thank you, Your Honor.
Thank you.
This is failure to pay rent. Rent is $26.15 a month. They owe April and the prorate of May for a total of $4,808 and back rent through today. A 1-day notice to vacate or notice to pay was hand delivered on March 6th. We're seeking back rent, court costs, and possession. This is not a CARES Act property and there's no government subsidies.
Okay. Good afternoon, Mr. Orta. Thank you for being here. Ms. Carcos is an agent. She works for a group called Nationwide. Typically, I see landlords hire her agency to come and represent them in court. So if you've never seen her or heard of her, sometimes people are confused. She is not the person on site who you may have otherwise dealt with. But Ms. Carcos received information from the landlord. Landlord says this is a case related to financial situation, so no other allegations. So, Mr. Orta, my first question is the amount of the monthly rent accurate? Is the flat rent $2,615?
Correct.
Okay. And then is it correct that April and May remain unpaid in full?
Correct.
All right, Mr. Orta, with that information, the landlord meets their burden on one of these types of cases. Can I answer any questions for you? This is absolutely the opportunity for the defendant.
Am I still able to pay?
I'll give you an answer, and then Ms. Carcos, if she has some information, she can share it. So legally, the landlord has won their case, and it is wholly up to the landlord whether or not they'd still like to try to resolve or settle with you. You could offer them all of the money and more money, and the landlord could tell you, thank you, but no, we'd
Yeah.
like you to be out within 5 days and call it a day, right? That is an option. You can still appeal, right? Sometimes the landlord does wish to negotiate with you, and if you wanted to pay it in full, the landlord could accept that. I have had landlords indicate to me that they wish to set aside the verdict within the first 5 days because they've received payment back in full. But legally, the landlord need not do anything except wait 5 more days, and if there's no appeal, move forward with possession.
And
All
what
right.
does an appeal do?
If you appeal, then this eviction is set out is essentially it's vacated. The eviction as though it did not happen, and a new court will hear the case. And then the new court will decide in the same way here, if the case is still about non-payment, has payment not occurred, was payment made late? That's all that has to be proven. If payment has been late, that would be sufficient grounds for an eviction. And then that court would give you a similar outcome, either how much money is owed, if there's been any fees earned, if there's any cost of court, they would set an appeal amount, and then you would have at least 5 days to appeal before a writ of possession can issue.
Okay.
All right. Ms. Carcos, do you by any chance have any information related to this particular landlord that Mr. Orta wanted to reach out to someone?
I don't. Just reach out to the office and see what they say.
Okay.
All right. Mr. Orta, what I can tell you is that if no one takes any action, beginning tomorrow is day 1. After 5 days, if no one does anything, on day 6, the judgment for what would here be $4,808, that would become final. And if you have not vacated, you or Ms. Orta have not left, the landlord can seek a writ of possession, which is a formal piece of paper that says, if you don't leave by tomorrow, the constable is going to come and peacefully observe me, remove you and your items from the property. And that is the effective way of getting back land. I'll also just tell you, Mr. Orta, the soonest the landlord can do that is day 6. You have at least 5 more days uninterrupted in the unit, okay? And the landlord has up to 60 days to do that. So they may seek, sometimes I have a landlord who on day 6 is down here, I want my writ of possession. And other times I have them on day 15, day 20, day 45, say, hey, I'm ready for my writ of possession. The tenant still hasn't left. Okay. All right. Mr. Orta, also when you checked in, if we got a good email address for you, we're going to send you, and that we send everyone always a copy of the order, but via email, you'll get it much faster. And that always automatically includes information about appeal. That's just standard for these cases. Okay, sir?
Okay, thank you.
All right. Then today it's going to be a judgment for the plaintiff. The amount of back rent is $4,808. The only additional money that adds to that would be the cost of court, so what it costs them to file it. Either party can appeal. If rent is $2,615, I would put the appeal bond equal to 1 month of rent. Yeah, I'm still good with that, which means it would be $2,615. Mr. Orta, you and Ms. Orta have the right to appeal. If you can't afford the appeal bond, you may qualify for what is known as an affidavit of inability. And again, we automatically send that information to both parties.
Thank you.
All right. If there's no questions, then very best of luck to everyone. All parties are excused. Thank you for coming, Mr. Orta. All right, our next case is 26-743. That's Polaris TX26 versus Hector Falcon and others. On behalf of Polaris, I see someone here on behalf of Polaris TX.
Yes.
Good afternoon. Tell me your name, ma'am.
Coco Sevilla.
Good afternoon, Miss Sevilla. Is there anyone here on behalf of the defendant, Hector Falcon? I see someone as a Zoom user. Rashad, did we have anyone check in for this defendant?
No, ma'am.
All right. Ms. Sevilla, we've not had anyone announced present. We are well into half an hour of the docket. Why is the landlord seeking to evict the defendant?
The defendant has not paid February, March, April, and then the prorated of May rent.
All right, so February through May, no rent.
Correct.
How much is the monthly rent?
721.
Is there any subsidy on the rent from the government?
No, ma'am.
And is the defendant responsible for all $721?
Yes, ma'am.
All right. Is this property under the Federal CARES Act?
No, ma'am.
What day was notice to vacate served?
March 14th, 2026.
All right. And how was that given to the defendant? Did y'all mail it, email it, hand it to them, stick it inside the apartment?
The notice was posted on the inside of the door.
Inside. Okay. To your knowledge, is Mr. Falcon currently deployed in the military?
No, ma'am.
Okay. Nope. I got the military affidavit. Looks good. All right. Non-payment 721 since February. February,
Correct.
March, April, so that's 3 at the full rate. And then May. You get $23 a day. Today we're on day 26, so $604 for this. Judgment for the plaintiff, $2,767 in back rent plus your cost of court. On appeal, I think it would be reasonable, given the amount of outstanding balance here in the rent, to put the appeal bond at double the rent for sure. That'll make it $1442. I think that's probably fair to all parties then. So judgment amount $2767 plus your cost of court. And then for appeal, either party can appeal $1442, and that's based on double the monthly rent of $721. Ms. Sevilla, any others today?
No, ma'am.
Thank you very much. Then all parties are excused.
Thank you, Judge.
Do I have someone here on behalf of the defendant, Rand Bronson? I see that we have a Rion Bronson in the courtroom. If you're able to hear me, you'll need to press *6 on your phone to unmute. We'll also send you a request. Good afternoon. Can you hear me all right?
Yeah, I can hear you.
Okay, fantastic. I can hear you as well. Thank you for being here, Mr. Bronson.
Yes, ma'am.
All right. Ms. Carcos, why did the landlord file for this eviction?
This is failure to pay rent. Rent is $19.75. He does only owe the prorated of May for a total of $1,656 in back rent through today. There's no government subsidies. A notice to vacate or notice to pay was given on May 5th, left inside the unit. It was a 1 day. We're seeking back rent, court costs, and possession.
Good afternoon, Mr. Bronson. Thank you for being here. Is it correct that under the lease, the monthly rent is $19.75?
That's correct.
Okay. And is it correct that May's rent has remained unpaid in full on time?
Yes, ma'am.
All right. Mr. Bronson, with that information, the landlord would win their case today. I'll give you the same information. Oh, I'm sorry?
Also, I do have one question. So, I'm currently, well, my stuff is still in the unit. I see like how the other cases, they will have like 30 days, 5 days vacate. I'm just making sure that I can get my belongings before, well, before they're like thrown out. I don't know if I'm already exceeded that point.
No. Okay, Mr. Bronson, that's a great question. I can definitely answer that.
Okay.
So today is the hearing.
Okay.
This is it. Today's the hearing, right? And today the judgment is going to be for the plaintiff. I would award the May rent $16.56. Okay. So the amount of money is $16.56 plus cost of court. And ultimately that may end up equaling what the full month of rent would have been. All right. In order for the landlord to remove you legally from the unit, they have to give you at least 5 more days. That's 5 calendar days. So you absolutely have tomorrow and then 4 days after that, right? So if you look tomorrow, 5 calendar days beginning tomorrow. It's on day 6. If you don't appeal and the landlord doesn't appeal and y'all don't come to some other agreement, the landlord can legally come to me on day 6 and say, I want a piece of paper that says I have the right to remove Mr. Bronson and all of his stuff. So let's say you've moved out, but you've left your furnishings or you've left boxes. The landlord with that what's called a writ of possession can legally take your boxes and your furniture and set it outside and be done with it. Okay.
Yep.
They
Thank
have
you. That's
to
it.
get an order from the court. And after the order is issued, they have to give you a notice of it, right? And they can do that, the soonest they can do it is day 6. They can wait up till day 60. So this is where I'd say contact your landlord. Sometimes the landlord is with it on day 6. Sometimes the landlord's like, no, that person's fine. We'll give them 10 more days and then we'll come and seek it. I just say that legally they cannot do it before day 6 and they have up to day 60 to do so.
Okay, sounds good.
All right.
Thank
All right then. Absolutely, Ms. Ronson. Those are good questions. So, okay. Final answers. It's judgment for plaintiff, 1656 plus their cost of court. Either party can appeal. The appeal bond is also 1656. And if neither party takes any action, judgment will become final and a writ of possession would issue after 6 days.
Thank you, Your Honor.
All right, Mr. Bronson, if there's nothing else, you're all excused. Thank you very much.
All right, thank you.
Thank you. All right. Next case is 26761, Mid-America versus Francisco Flores. I have someone on behalf of Mid-America.
Yes, good afternoon, Your Honor. Jose Vasquez for Mid-America.
Good afternoon, Mr. Vasquez. And do I have anyone here on behalf of the defendant? Francisco Flores. No, not checking anyone. All right, Mr. Vasquez, why is this one sought?
Yes, Your Honor. This is for non-payment of rent for the month of May. The base rent is $11.53 and is not subsidized. We are not a CARES Act property. The 3-day notice to vacate was delivered on May 4th via certified mail. Today, we are currently asking for collection of back rent and possession of the apartment.
All right, had they been late on the rent before May?
They have, yes.
Okay, and it's just for May, 1153.
That is correct.
All right. Is Mr. Flores in the military? No.
No.
I see that. Got a military affidavit, got the return of service. Alternate service, Deputy Gambo attached it and mailed it. Okay. Mr. Vasquez, I'm gonna highlight, let me finish this and then I'll share some information with you when I looked at my docket for Thursday, okay? So for this case today, for cause 26761, Mid-America versus Francisco Flores, it will be a judgment for the plaintiff. We would award $967 as rent, and we would set the appeal bond equal to $11.53, which is the full month of rent. You would also receive cost of court and your filing fees. So that will be judgment for plaintiff. Mr. Vasquez, I happened to look at my docket for Thursday, and I noticed that we had 3 filings from Mid-America, but maybe review those filings. Those filings were filed in the name of the agent and not the name of the landlord. That I'll just highlight that when I looked at them, I thought that's odd to me. I'll draw your attention to it now before it is Thursday and we were actually in court for those hearings, okay? I'll just say you can contact the court, take a look at those, but there's 3 and they are from Mid-America because they are the exact same way, but they are filed in the name of someone other than Mid-America.
Okay.
Okay, so
Mhm.
I'll leave you with that information.
Wonderful. Thank you.
Absolutely. I think that's the only one you have today, though. Any others?
Nope, that should do it for me.
All right, thanks so much. Then you're all excused. Have a good afternoon.
Thank you as well.
All right, then I have 26771. AMAA Onion Creek versus Casey Urias, Miley Robles, and others. Do I have someone here for Onion Creek?
Hi, Judge Holmes, Kaylee Samuels.
Good afternoon, Ms. Samuels. Do I have anyone here on behalf of our first defendant, which is Casey Urias?
No, they will not be joining us.
Okay, nothing on behalf of Ms. Robles. All right, Ms. Samuels, why was this case filed?
It was for non-payment of rent, but I was actually speaking with Brochet to see if there's any way we could do a continuance for, she gave me the option of 1 week or 2 weeks.
Okay, Ms. Samuels, I'm fine with that.
Yeah, the resident called actually while I've been in here, saying that they were pending approval for somewhere else to be able to vacate.
Okay, I'm fine with that. Why don't we do 2 weeks? That way everything gets verified. If you
That would
still
be
you're
perfect.
lacking, you haven't lost it. You're still where you're at, but that's giving some reasonableness to both sides. All right. I'm gonna make my clerk happy and ask her, Brochet, would you rather we reset to Tuesday or Thursday, week after that?
Let's do the 11th
Okay.
at 2. Yeah.
Okay. Yeah. No, absolutely, Ms. Samus, happy to do so. That's.
Okay, perfect. Thank you
If
so much.
y'all, if what I would say is if the plaintiff and the defendant are working it out, I don't need to involve, like, I don't have a dog in this fight.
You're like, I'm just the middleman.
Yeah, right. If y'all don't want it, cool. That's fine with me. All right,
Okay,
Ms. Daniels, if
awesome.
that was your only matter, then yeah, absolutely, you're all excused. And thank you for your patience, right? You could, I really appreciate that.
Yeah, of course, no problem.
All right, well, have a nice afternoon then. Thank you.
You as well. Thank you.
That's gonna bring us to our final matter, which is cause 26750. This is Reese Harrison versus Jonathan Accord. Do I have someone here on behalf of the plaintiff, Reese Harrison?
I'm here, Your Honor.
Good afternoon, Mr. Harrison. Thank you for your patience. You've gotten to see lots of examples, so I appreciate that. All right, and I can look around the courtroom and see there's no one else here, so we do not have anyone appearing on behalf of the defendant, Jonathan Accord. I will confirm service, but Mr. Harrison, tell me, why are you seeking to evict the defendant?
Unpaid rent.
Non-payment? Okay. How
Yes,
much
ma'am.
was rent monthly, bi-weekly, annual?
$2,000 per month.
2,000 per month. Okay. And did you receive any subsidy directly from the government for that rent?
No, Your Honor.
So all 2,000 is the defendant's. What months of rent remain unpaid?
He owes for the latter part of February. The lease was the 15th through the 15th. So he owed $1,000 for the balance of February, $2,000 from March 15th to April 15th, $2,000 from April 15th, May 15th. So that would be at $5,000. Through today would be $733. So $5,733.
Okay.
I sent him a notice to vacate, a 7-day notice to vacate by email on March the 30th. He responded the same day acknowledging that email. And we also have had text communications back and forth.
All right, your email is absolutely sufficient. You've given him 7 days, is very generous, and because he had been late with the rent before, you were not required to give him any type of pay or vacate. You could just say, please leave, and that is fine.
Yes.
Looks good to me. I can see that we got back the return of service. You received in-person service directly from Deputy Hobbs, so Mr. Accord is aware of the lawsuit and the fact that he had a hearing today. All right. Mr. Harrison, it would be a judgment in your favor. Back rent $5,733. I find that to be reasonable. You've done all your calculations. Kudos on that. You said Mr. Accord, per your knowledge, and also you've recently spoken to him, he is not in the military, so no worries with that one.
No, ma'am.
Okay, for appeal, February, March, and April, May. For appeal, I would typically at this stage, I would double the rent, and therefore the appeal bond would be $4,000. I'll just say that he can do that either with cash, with surety, or if he doesn't, if he qualifies to, if he wanted to appeal, he might also qualify for an affidavit of inability. But typically, when rent has been that far behind and it doesn't exceed the judgment, I would double it. Okay, Mr. Harrison.
Yes, ma'am.
Any questions?
I have one question, if I may,
Absolutely.
please. So I understand the 5 days starting tomorrow. So if he's not out on day 6, then what document do I need to receive from the court so I can physically remove his possessions?
We're going to send you an order today. So that's all you would need. And if on day 6, typically, and this is not legal advice, I will give you information about a common way people do this. It's not uncommon. A landlord would call us on day 6 or 7 and say, hey, did the defendant appeal? Has anyone filed anything? And if there's no appeal, then the landlord contacts the constable's office. They say, hey, here's my order of eviction. No one appealed. I want my writ of possession. You pay a fee. Constable issues it. They bring it to me. I stamp it. Constable goes, contacts the defendant, puts it on the door. No one's there the next day. The constable gives you information. You get to go ahead and move forward with getting back possession.
Okay, so I'm sorry.
Day 6, start with our office.
Start with your office. I'll do that. Thank you so much, Judge.
You would want to confirm that there's no appeal, and you can confirm that with our office. And if there has not been an appeal, nothing has been filed at that stage with our order, you can go to the constable's office, which is in the same building, or via email or phone, and seek about a writ of possession.
Thank you, Judge.
Absolutely, Mr. Harrison. Thank you. If there's no other questions, you are all excused.